Good afternoon, Your Ladyship, the Honorable Chief Justice, Your Lordship, Justices of Appeal, Your Lordships, Justices of the Supreme Court, His Honor the Chief Magistrate and Resident Magistrates, Registrars, members of staff, members of the bar, staff of the judiciary, members of the casual attending, and all other attendees. Welcome to this afternoon's feature presentation, Recusals on a Small Jurisdiction. I'd like to specially welcome the Honorable Justice of Appeal, Justice Vashit Kokaram from the Judiciary of Trinidad and Tobago. You have been shared his bio, and it will be shared again in the chat. So without further ado, I'd like to welcome Justice of Appeal Kokaram, who will lead us in this afternoon's presentation.
Thank you very much, Chair. Are you hearing me loud and clear?
Yes, I am, Justice Kokaram.
And I'll adopt all the protocols established. And you're seeing my slides.
Yes, I am, Justice Kokaram.
And that's a topic that I'd like to address this afternoon, our Honorable Chief Justice and Caribbean colleagues. The topic given to me, I have to recognize Ms. Carter, who my former GRC, who gladly gave me this assignment. I think she helped me in one of my judgments on recusals. Recusals in small jurisdictions. And I want to look at it on this aspect. Do we get a free pass because of our local circumstances of the limited judicial pool? Or is it a source of heightened precaution when it comes to the question of recusals? I start with the very interesting comment by Lord Diplock that there's a fundamental human right to a legal system that is infallible. It's not to a legal system that is infallible, but to one that is fair. And the whole concept behind the doctrine of the law of recusals takes us into a very thorny area of an imperfect human legal system. Let me put some case scenarios up on the screen, and you can raise your hand if this has happened to you. But these are some troubling areas of the law of judicial recusal I'd like to address with you. And it really underscores the question of judicial independence, our integrity, and our accountability. I should commend to you two papers which are very inspirational, one by Justice of Appeal Nelson, which is available online, on the law of recusals, I think authored in 2014, and Justice, as he then was, and Judge of the Caribbean Court of Justice, Justice Hayton, his 2010 paper on the law of recusals. Very good Caribbean resources on this troubling area. Personally, I have had over the years on the bench to recuse from a number of matters, as some of my Caribbean colleagues would have done for many reasons. Perceived associations with corporate clients, recent connections with law firm in which I was a partner before my appointment. This is a nice one. A perception of animosity against an attorney due to my sister's divorce from that attorney's brother. I was happy enough to quell that dispute on a one-to-one private chat with that attorney at law. But there was an interesting accusation in the case of Gafour and the Attorney General that I could not sit to hear a case concerning the constitutionality of the dismissal of a member of a statutory board by our President of the Republic on the basis that that same president had appointed me to the office and I'm beholden to him. That was found to be a baseless allegation of bias. But having said that, my many interactions as chairman of the Mediation Board of Trinidad and Tobago did cause me many sleepless nights. These interactions with several government ministers and ministries, how is that to be perceived? And what can I do to instill trust and confidence that I will remain impartial and not to be perceived to wink in favor of those whom I had had to interact in carrying out my duties and social responsibility? So let me begin with these three troubling areas. Again, raise your hand if it happens to you. Let's look at the judge and her laptop. So a judge is conducting a hybrid trial in a sensitive case to determine who inflicted fatal injuries to a child, and in which either of the parents who were separated when the child incurred those injuries, they might be implicated in the crime. The mother was giving evidence in person, and this is in 2020, this is during our pandemic, with a mask. Cross-examination continues on the second day, and she complained of blurred vision, backaches, and then the following day she started to complain that she had a cough. And so the judge had to adjourn the proceedings so that the mother could give her evidence at the mother's home. But after the court rules, the judge, again, raise your hand if this may have happened to you, the judge took her laptop to her chambers with the remote link still open. And what everyone overheard on the link was a conversation she was having on the telephone with her clerk of her frustration of this mother's delayed tactic. And the mother was trying every trick in the book to avoid answering these questions. And she made all these pejorative remarks. But in a few minutes, it was these comments were made until her usher rushed into the room and told her to close the laptop. If you were that judge, would you recuse from hearing this very serious case midway through this lengthy trial? Now, in that case, it actually occurred in the UK. The name of the case is Recusals 2020, English Wales Court of Appeal, Civil 987. The judge invited submissions from the parties as to whether she should continue to sit. She regretted what she said. She understood the hurt that her comments may have caused the mother, but she felt that her robust management, her robust comments had not crossed the line, as they were private thoughts, and there was little impact that those comments could make on her assessment of the mother's credibility. And she made no predetermination of whether the mother was a liar or she cannot be believed. Now, she reached her decision to continue to sit with the greatest of hesitation because she was mindful of the length of the trial and the very heavy workload of other judges if she had to recuse. Now, what do you think? Do you think that was good enough for her to continue to sit, or would you have decided to recuse in that scenario? And the question here would be, will the limitation of judicial resources in small societies be good enough to give us a free pass on the perception of bias? Now, the Court of Appeal was very sympathetic with the plight of the judge, and the Court of Appeal reversed the decision and ordered that she should have recused from hearing the case. They felt that she had crossed the line, and applying the informed, fair-minded test, or the objective test of Porter and McGill, they held that the privacy of the comments did not salvage the matter as they were broadcast during the mother's evidence. The judge made highly critical remarks of the mother's honesty without giving her the opportunity to answer that perception, which a person from the outside looking in would think the judge's view was colored and demonstrated a real possibility of bias. And it was a case of a real ground of doubt. And that doubt should be resolved in favor of recusal. And that's a famous, famous tagline for us as judges: if in doubt, out. And that is what the Court of Appeal felt in this case. But they also made this very interesting observation. They were very sympathetic with the judge's plight. And they said that what happened is undoubtedly a consequence of the tremendous pressure under which judges at all levels find themselves at present, and against all powerful odds in the pandemic. They are faced with staff shortages and all the difficulties, technology and otherwise, presented by remote hearings in particular. But the bottom line is that the exigencies and the pressures of our work is no excuse for crossing the line. Second case, again, raise your hand if this happened to you. What is this case called? The Judge and the Speculator. All right, so here's another family proceeding between parents in relation to their child to determine the appropriate parenting plan. Where should the child go for university, for secondary school, and then on to university and the like. The mother applies to the judge in the middle of the hearing again to recuse from hearing this application. She complained that the judge was kept muscling her to go to mediation. She complained that on an earlier occasion, a few months ago, that the judge had released the father on bail when he had was arrested and charged for a domestic violence offense, and released him on bail to attend a plea court in unusual circumstances, and that she, the judge, was the sister of a police inspector who is a very close friend to the same father and the paternal grandfather. 2 tenures, or would you recuse from hearing this case? Food for thought. And in the case of VSE and TRT 2023 decision, some of you may know of this one. This is from our own Caribbean jurisdiction of Bermuda. The High Court judge had decided, I'm not stepping down. She referred to the correct principle, Porter and McGill, the fair-minded and well-observed test, the fair-minded and well-informed observer test. She noted this was a case where the best interest of the child takes precedence. She was robustly managing this case. She invested a lot of energy in this case over the months. And she made the point that in small jurisdictions, like in Bermuda, it is not always easy to find the appropriate judge. And if this objection is taken, as it is so often does, at the last minute, it will lead to delay and cost. And she said, considering Bermuda's geography, population, size, cultural and social history, and her specialist role in the Supreme Court, the well-informed observer in Bermuda will not perceive any appearance of bias on her part. Trust me, I can do this job. That's what she is saying. Now, importantly, the judge refused, even when requested to do so by the mother, to divulge any details of her connection to the grandfather, the paternal grandfather, and she refused to disclose any relationship to her, any information on her brother's relationship with the father, or the circumstances in which bail was unusually granted by the judge to the father. And her response is, in a short statement in her judgment, that she was continuing to sit, the mother's perception of the judge's connection to the judge's brother and his relationship with the father's family is just that, a perception, full stop, without explaining why. She felt that that was just mere speculation. So should she get a free pass because of our close connections in our community, because we are close-knit, and we should accept that as part of the fabric of our culture? The Court of Appeal in Bermuda, Justice of Appeal Gloucester, obviously said the right thing. The answer is no. She ought to have recused. The failure to give any explanation as to the true extent of her connection with the father's family and of her participation in the release of her father on bail provides support for a real concern of bias. Absent a transparent account of the extent of the connection, the objective observer is left fearing the worst. And so the question of transparency, sanitizing that relationship, and holding up the judge as being distant from that connection, which may be any relevance to the issues to be determined, that was missing for that judge to actually say that the well-informed observer would not think that she was biased, and so she was ordered to step down. Third short story, third case, I call it a case of robe disease. What's robe disease? When sometimes, we put on the robe, we feel that we have this power, like Darth Vader, the dark side of the Force takes over. We've been given this great degree of trust and reverence from from society, from members of the public. We feel that we are superhuman. So here's a judge who is especially empaneled with other members of the appellate court, and their mission, their role was to decide on the correctness of two earlier decisions made by the Court of Appeal. And one of those decisions was authored by that very same judge. Would you, if you were the judge, sit or recuse from hearing that appeal? And with the fact that you have other members of the panel with you present, would that sanitize the decision-making process, even though you presided over the judgment over which you are now examining to determine whether that judgment is right or wrong? Now, in a very robust judgment, Justice Arun Mishra, in the case, this was happened in 2009 in Indoor Development and Manohar in India, I am not biased and don't get influenced by anything on earth. So I call this the robe disease. If I am satisfied, then only I will recuse myself from hearing the case. I'm trained to be impartial. Well, that obviously is the wrong test. But it reminds us of a very funny case of Justice Scalia way back in 2004, Scalia, in the case of Cheney and the US Vice President Dick Cheney and the United States. Justice Scalia was sitting in a matter in which he was very close friends with Vice President Cheney. In fact, he went on a duck hunting trip with Cheney, and Cheney had paid the plane tickets for his transport to get to the place where they were hunting ducks. And of course, there was an objection made by one of the interveners in the case to Justice Scalia's involvement. What did Justice Scalia do? He said, I'm not stepping down. If it is reasonable to think that a Supreme Court justice can be bought so cheap, the nation is in deeper trouble than I had imagined. Of course, they have their own different system. These decisions cannot be appealed. But there can be little quarrel that Justice Mishra and indeed Justice Scalia was applying the wrong test of bias. I call it being affected by what we call robe disease, which can afflict us from time to time if we misunderstand the trust that small communities place in us. Very recently in our community in Trinidad, judges in the High Court and the Court of Appeal in two unrelated matters had to step aside in the middle of the management of their case. In the one part for the High Court judge, her husband's close affiliation with a ruling political party where the case before her was politically charged, even though the parties were not political parties before her, and the legal issues were far from it. And in the Court of Appeal, in the eve of giving judgment, the judge discloses her brother's directorship on the board of one of the parties in a matter involving the propriety of the decision taken by that board many, many years ago. But I found another case that I thought was illustrative of some of the difficulties we have in this law of recusal, and that it is a trouble area. Wayne Kublal Singh and the Attorney General of Trinidad and Tobago, Justice Abood, as he then was, and this decision was affirmed in the Court of Appeal, famously refused to step aside from hearing this matter brought by Wayne Kublal Singh and the others to stop the government from building a highway, even though the judge's brother was a strong supporter and lobbyist for this environmental cause, for the highway reroute movement, appearing on viral videos. But the judge disclosed his details. He was, unlike the judge that we saw in Bermuda, disclosed his connections, if there were any, sanitized the relationship in full disclosure, and demonstrated in a robust judgment that I am not my brother's keeper. So I thought I would share this from his judgment, which was very enlightening. Mere brotherhood with an environmental activist who is not a party in the case, and I think that was critical for him, cannot be reasonably perceived by the fair-minded or informed observer as creating apparent bias. Unlike the case of Pinochet, which you all know, which was also argued on the ground that Lord Hoffman's wife was an employee of one of the parties, no one could deny that Gary Aboud and I are grown men, living in separate households. In fact, those who are well informed will know that Gary and I haven't lived in the household for 35 years. And we're both in our 50s. I have pursued a career that upholds the law. He has pursued a career that puts him in danger of breaking the law. And there's no evidence that we come from a family that is more well-knit than any other family, nor that our family, like every other, does not have disputes among its members as to what they say or what they do. Are you comfortable with this statement made by the judge? It was upheld, and I think the demonstration of the lack of association there was sufficient. But it would be futile to analyze all the case law that we have on the law of recusals, to use it as a guide to our approaches as judges in a small jurisdiction. The difficulty here is that the law of recusal is judge-made law, it's common law, and fact sensitive. And we must, I think, as a guide, rather be more sensitive to the underpinning purpose of the law of recusal to help us make the informed choice when these types of cases occur with us. Now, from this quick survey as well, it demonstrates it's often the case that judges in small communities will be placed in a continuing dilemma. We will know persons before us, or we may know the attorneys at law. We may meet a witness in a grocery. We may be sitting next to a party unknowingly in the plane ride or ferry ride to the court. Dare say, should I say, we might be playing mass with a relative of the party in a Juve band, where, you know, in Carnival, all of we is one family. Or we may see someone in the back of our courtroom, one of the witnesses or party, smiling at us from time to time. And when you do your own background checks, you realize that that was some pumpkin vine family that you were unaware of. But does this context of close associations in small communities provide any reassurance that only we as Justice Mishra, so confidently espoused, will know when our impartiality is affected? We are trained to know. Does that context provide any reassurance that the public must trust us to do the job which has been assigned to us and maintaining the highest ethical standards? Instinctively, you may think that being a judge in a small community may call for a different standard. But who else would do this case? We can't all be persons locked away in an ivory tower. We have to connect and interact. And that's the underpinning of my topic, you know, in small communities, should we get a free pass on demands of accountability and trust? Should we get a free pass? Arguments of necessity apart, In answering the question, should we get a free pass? While local customs and conditions might inform particular decisions, it will be treading dangerous ground to answer that question. It depends. To travel the less controversial route is to say, do we earn a free pass? Answer is no. There's a heightened precautionary principle for us to guide us in our approach to recusals and even as our conduct as judges in our community. Are these principles of recusal common to all societies? Or is it in the application of these rules that we must give deference to the culture of our Caribbean society? And what is our culture? A history of enslavement, colonialism, coming out of that fierce independence, hospitality maybe, but a heightened degree of suspicion of authority. Cutting through all of that is a universal gold standard of trust. And recently, in the Privy Council's decision in Smith and the Attorney General, the Privy Council confirmed that there may not be a free pass for us to decide on when a judge should recuse, as the standards to be applied are international ones. The lower courts in that case were of the view that the chief magistrate who was presiding in a case, despite allegations that he was beholden to the Attorney General, who was a party, in a politically charged indictment of the appellants for fraud and corruption charges. The Privy Council was very robust in saying that no deference was to be shown to the decision of the lower courts on the application of the Porter and McGill tests. Both the lower courts said that there was no apprehension of bias. But the Privy Council said that while local customs, attitudes, or conditions were of direct significance and matters which local courts were better placed to assess than the board, no factors were in play in that case, where what was to be determined was the application of the correct legal test to undisputed facts. No deference is to be shown to the lower court on the question of bias, as it's an objective test, and according to the Privy Council, it involves universal principles. And those universal principles are affirming the principles of integrity, independence, impartiality, our own propriety, the fundamental respect needed for the rule of law, and the operationalization of the separation of powers and a functioning democracy. So fundamental to independence as judges is our accountability for the work that we do. And while we measure our fallibility as humans, recognizing that this is a human system subject to the frailties of humanity, we recognize the essential values of our human system, our human legal system of trust, respect, faith, confidence, which underpins the rule of law. And respect is fundamental to achieve that trust to produce significant life-altering decisions. And so this question of judicial independence and efficiency in our work, these are just institutional labels that treat with the significant concepts that underpin them: our moral authority, our legitimacy as judges, and our relevance as judges and the legal system. Without legitimacy, we have no moral force to guide and shape the futures of our society. Our independence is meaningless. And without relevance, our efficiencies are mere statistical, lifeless data. So we want to explore in the time that we have the question of the underpinnings of the law of recusal. We want to examine the test of apparent bias. I'll focus on that. And the troubling areas on the apparent bias on adverse, where we make adverse comments, social media, and we will conclude with some areas of reform. Turning to the question of trust and why important, and as I said, understanding this, where we are coming from, and we're looking at the underpinnings of the law of recusal is important as a guide. There is a very interesting old novel, The Moral Basis of a Backward Society by Edward Banfield. And he described a village in southern Italy in the 1950s, mired in poverty and ignorance, because no one trusted anyone's motives. Neighbors couldn't pool their limited resources to provide for more efficient farming because everyone assumed that the other person will take advantage of the other. They weren't able to move forward. They began focusing their energies on preventing others from moving forward. So a farmer who planted 6 fruit trees in the morning woke up to find it destroyed. The mayor turns down help from others because he was fearful that he would be suspected of taking some of the money for himself. And so there was a cycle of mistrust and distrust that led to the society cannibalizing itself. And Banfield said that the inability of the village to develop the common good was grounded on an assumption that people acted for their immediate material interests. Having given up on getting ahead, they focused on others not moving on either. They dealt with greatest suspicion. And this culture of distrust, there are no leaders and no followers. Is that true of our Caribbean society? For the very least in Trinidad, Dr. Hutchinson, Professor Hutchinson, famous, one of our leading psychologists, said at a mediation conference that one of our difficulties is that we have a society of high degrees of mistrust. The only thing that we trust is that the next person is not to be trusted. Very interesting. But when our JEI did a survey from users of our courts and persons coming out of our magistrates' courts and high court, some of the responses were startling. A very low degree of trust. How can citizens speak up when there's no trust in the legal system? I have no faith in this court system. I felt as though I'm treated as a victim rather than someone who's seeking to do right. Accountability and trust are very important matters for our rule of law, and as Banfield explained, a properly functioning society. Now, there are some dated judicial commentary which observe that a judge is only accountable to his conscience and the law. And we know now that in today's world, where we play such an important role in the development of our society, any notion that we are beyond reproach holds no currency. And so I make reference to a very old calypso. I wouldn't sing it. The Mighty Spoiler. He sang this calypso, The Magistrate Try Himself. Some of you might know it. It's a funny case about a magistrate charged in his own small district with speeding by the police. So the whole town come out to see the magistrate trying himself because there's no other magistrate to try the case. And he felt that he was a magistrate beyond reproach, the guardian of the rule of law, and so he can conduct this trial impartially. And so the song was about the trial of the magistrate conducting the trial as a conversation to himself. And this is what and the chorus was, himself asked himself, you are charged for speeding. Himself told himself, the policeman lying. Himself told himself, don't shout. And he charged himself with contempt of court. Now, in the typical witty way of Calypsonians, they're making the point of that view of judicial officers being accountable only to themselves. And it's a cynical question. Who will guard the guards? In whom should we place trust that we are truly impartial? And that's one of the problems. Another problem that we have is the question of impartiality as opposed to neutrality. Can we be entirely impartial? Impartiality connotes the absence of bias. Now, realistically, we are all imbued with an inherent bias from our own life experience. The American judge Jerome Frank had said once that if bias and partiality are defined to mean the total absence of preconceptions in the mind of the judge, then no one has ever had a fair trial, and no one ever will. So let me see if we could put that to the test. Let me see which one we could choose from. Maybe we can use this one. It might be easier. The image that I'm throwing up on the screen, I think many of you would have seen this. Is this an image that comes to mind immediately as of an old woman, a young woman, or someone else? So you can put in the chat whether you're seeing an old woman or a young woman. Young first, old after you said it, and now seeing both, something else. Oh, I love it. I love someone who said something else. Because when I showed this to a group of law students, someone told me they saw some animal. I don't know. Or what is it that you're seeing? So the problem here is about perceptions of reality based on how we're wired to see different preconceived notions of what exists and what is true and what is real. And the problem is, you know, we will all have different perspectives on the very same truth. So here we have the hair of the young woman, a profile of the young woman's face. This is her nose, and her little jawbone comes here, nice little jawbone, her ears, and this is a necklace for the young woman. But this is also the mouth for the old lady. This is the old lady's eyes. This is the big old nose of the old woman. So, and this is a fur coat and so on. So, question of impartiality, you know, must be viewed in the context as every human being is exposed to our own life experiences, which will shape our own notions of reality and our own perceptions of truth by a process of education, socializations, our attitudes and outlooks are shaped, which will inform our decision-making process. The problem here is this: it is our duty to adjudicate does not translate an obligation to ignore one's own experiences. And that's always a challenge for us as judges. You know, we have been brought up in a certain way. We're brought up in different silos. And that is why it's all important for us to be exposed to different views and different perceptions of different parts of our different aspects of our community and community life. And the problem of that is the closer we get to our society, the more that we become so involved with them, we may be accused of being too closely associated with the very society that we have to be impartial and hold a higher bar to our duty to be neutral. But Justice Corey and RNS usefully observed that the requirement for neutrality does not require judges to discount the very life experiences that may well qualify us to preside over disputes. The duty to be impartial does not mean that a judge does not or cannot bring to the bench existing sympathies, antipathies, or attitudes. Rather, the wisdom required of a judge is to recognize and consciously allow for, and perhaps to question, all the baggage of past attitudes and sympathies that fellow citizens are free to carry untested to the grave. And that's one of the values that we have of Judicial Research Council as well. You have a case coming right up in front, or even you sit in appeal court, appellate level with colleagues. This is my bias. This is my, if you are able to recognize it, this is my unconscious bias. In this case, put it out there and try to deal with it. Although impartiality does not require the judge to be devoid of sympathies, it requires us to be free to entertain and act upon different points of view with an open mind. And so our training when we are adjudicating, yes, we have experiences outside of the law, but in exercising our impartiality, we have to put those experiences sometimes aside. Now, bias is the opposite of that notion. It connotes closing our mind, being affixed to the preconceived view that there is only a young woman in this picture, that there's only an old woman and nothing else, remaining inflexible. And that is where bias becomes insidious. That's where our unconscious bias takes over our logical thinking. And Lord Phillips reminds us in Medicaments that bias is an attitude of mind which prevents the judge from making an objective determination of the issues that he has to resolve. He may be biased, not necessarily in favor of an outcome of the trial, but because he harbors a prejudice in favor of a particular witness, it prevents his impartial assessment of the evidence of that witness. From this evidence, there's clearly a young woman. Never could exist the possibility of two ladies in that picture. I thought Lord Devlin said it best in the case of Lowell and Northern Spirit Limited. It's an old case, 2003. He says the judge who gives the right judgment while appearing not to do so may be thrice blessed in heaven, but on earth is of no use at all. And Kirby, in the case of motor repairs and Coltex Oil, 1988, at stake is not just the acceptance of a judge's decision by the litigants, but the acceptance by the community of the administration of justice by judges. And so it is useful to note then that we have in our Caribbean identified and we have solidified the Bangalore principles of impartiality when it comes to judicial conduct. We have these principles of impartiality in our own jurisdiction in Trinidad. And in Turks and Caicos, impartiality is necessary and important in the discharge of judicial duties. Of course, these are the gold standards of our judicial making process. What is the rationale for this rule, and what are some of the fundamental principles? I would like to, in this part of the presentation, summarize for you some of the underlying principles that give rise to the rule on bias. Of course, it all stems from the concept of justice must not only be done, but seen to be done. And if you want to extend that even further, for those of us who have developed and have looked at therapeutic jurisprudence, justice must not only be done, not only be seen to be done, but it must be felt to have been done. Procedural justice, of course, plays a very huge part in the law of recusals as it builds trust in our ability to adjudicate. We provide accountability for what we are doing. And in doing so, we provide a level of respect for the parties who are before us, and in that environment, allow them to have an effective voice. So here are a couple of fundamental principles. If I can summarize them from all of the case law. Justice must be seen to be done, as I've espoused, I've explained. There's a presumption that judges can disabuse their minds of irrelevant personal belief, having taken the oath of office, but that presumption could be displaced by the relevant evidence. There is a duty to sit, and judicial officers should not accede too readily the suggestion of the appearance of bias. I think New Zealand's Court of Appeal in Miro and the Commissioner of Inland Revenue put it well in terms of the requirement of independence and impartiality is counterbalanced by the judge's duty to sit. Fourth, no rules of recusals do not give a litigant a veto power over who's sitting on their case or to engage in forum shopping. And of course, a judge who decides to recuse, no lawful authority could order him to do so. Bias is, fifthly, an insidious cancer on our system. Having said that, a recusal application is a serious allegation to make of the decision maker. So ill-conceived and baseless applications to recuse ought not to be made or entertained. And this is where the attorneys need to be of some assistance in educating their clients on these types of applications, as ill-founded challenges to the bench should not be entertained, and courts should be assiduous in upholding the impartiality of judges. So the onus lies on the applicant to make their case of bias. 6, the judge will then engage in a sensitive exercise to preserve the dignity of the judicial office, the requirements of due process, the fundamental principle of the rule of law. 7, of course, as we've been mentioning all along, which you're well aware, the test for recusal is that in our neck of the woods, following the UK position, is that of the fair-minded and informed observer, whether he would conclude or that person would conclude that there was a real possibility or a real danger of bias on the part of the judge. In that very same case I had referred to in Wayne Kubral Singh, Justice of Appeal Mendonca in the appellate court, identify the words real possibility and real probability as identifying the burden on the person alleging apparent bias is not as onerous as the burden of proving that it is more likely than not that the tribunal is biased. Of course, the test is objective and requires the court to ascertain the view of the public through the eyes of this fair-minded, informed observer. So what the judge thinks, what Judge Mishra or Judge Scalia thinks is of no moment. The rule of bias, 8, gives life to the constitutional guarantee of due process. 9, the rule of bias should be contextualized against the principles of what I will call procedural justice, which I have just identified, and what I will call judging with a therapeutic key. Now, the discipline of therapeutic jurisprudence is something that is fast becoming fashionable in the Caribbean jurisdiction. Therapeutic jurisprudence originally originated with the practice of in problem-solving courts and mental health applications. It considers the role of the law as a therapeutic agent and underpins the practice of problem-solving courts. But it also advocates the use of social science to study the extent to which a rule or practice promotes psychological and psychological well-being of the person that the law affects. And there could be no better application of therapeutic jurisprudence when it comes to building trust in the persons who are before us and in our communities, in the work that we do that is being discharged by an impartial bench. Therapeutic jurisprudence also emphasizes notions of empathy. And in one of my judgments, Sugrim, where I had declined or refused an application to recuse, I had written the judgment along the lines of being sensitive to the needs of the client, and understanding and being empathetic to his need for a fair trial. So some level of empathy must be had by us in these allegations of recusals. They're very, as humans, we have our egos, and if someone says that we can't sit, in other words, we can't do our job, it strikes to the core. How could, how dare you? But we have to be humble and compassionate and understanding that that is also our part, and that is a good indicator. And I'm happy that they've raised it so that I can always do a self-check to ensure that I keep an objective, fair, and open mind. Regardless of any application for recusal, that also is my job, to keep an objective, fair, and open mind. So embrace applications for recusals, of course, those that are well-founded, to interrogate, am I on the right track? And that's a therapeutic approach. And then 10, of course, the rules on bias depends on the material facts, which are not limited to those that are apparent to the applicant. They are facts which were known then and known upon investigation by the court. And the court must make an objective appraisal of the facts that is in the public domain. And of course, as we mentioned earlier, when we're looking at the case scenarios, the court will apply the recusal test against the background of traditions, history, culture, of useful authority. There are two useful cases: Belize Bank Limited and the Attorney General, and Grant and Teachers Appeals Tribunal, 2006 Privy Council decision. Importantly, in the Grant case, the Privy Council had said, in small communities, it's commonly found that many of the parties and witnesses are known to the judge assigned to sit. And this is where my concept of whether it's free pass or heightened precaution arises. They also said it is incumbent on the judge to apply a careful and sensitive judgment to the question whether he's a close enough friend of the person concerned to make it undesirable to sit on the case. And then finally, well, these are just fundamental principles we can call from all the cases. And ironically, if you want to instill confidence in our system, we're back to spoiler and that Calypso, himself to himself. Who makes the decision? The judge himself decides if I am impartial or not. So we have the temptation of a Mishra or Scalia coming. The judge sits on his own course to determine whether he's biased. I interrogated that, and my area of reform was as I'll come to in a moment, was to find another mechanism rather than letting that poor judge decide for himself, affected by all the subconscious and unconscious biases that we may have. But she said to me, my GRC said to me, she said, but the society trusts you to be superhuman. That's your job. Your job is to determine impartiality. Your job is to be detached. Your job is to be the man in the mirror, and you can make that judgment call. So it's a good system for you to decide that question. But that's something that we can debate this afternoon. I thought that turning to grounds of recusal, some of the disqualification or recusal can take place where your interests conflict with the outcome. That's relatively easy. where your associations and professional, family, personal, and professional. Let's see if I get this right. You have expressed opinions and recent history give you the appearance of partiality, actual bias or prejudice, where a judge sits on appeal from his own decision in a case or issue tried by him, where a judge of a final court of appeal refuses to recuse and takes part. It may not be reviewable. Locker bail, useful case, and in giving some of circumstances in which an objection could be based. Everything is, of course, dependent on the facts. And they cannot conceive of circumstances in which an objection could be based on these following factors. But again, these are all fact specific, and there's no one silver bullet to answer this question. In US and Cooley, some guidance of where there are no grounds for recusal in these cases of mere speculation. And of course, these are all context as well. The mere fact the judge has previously expressed an opinion on a point of law or expressed a dedication to upholding the law. Again, as we look at the case law, it's the question of how strong and robust was that expression, and how germane and relevant is it to the issues you now have to decide. Prior rulings, same issue. Mere familiarity may not be a ground for recusal. There must be a close connection. Baseless personal attacks, well, we must try to avoid all that by all means. Personal opinions or characterizations appearing in the media, and notoriety, threats or attempts to intimidate the judge. And I think in some of our judgments, you would see that we look at some baseless allegations or recusal as a threat to our own independence. Similarly, in locker bail, they've given us some guidance as to where real danger of bias may arise: personal friendship or animosity, close acquaintances with family members of the public involved in the case, especially where credibility is involved. Cases where you've rejected the evidence of a person in outspoken terms as to throw doubt on your ability to now assess the credibility of that person's evidence with an open mind. If you've expressed views which would have thrown doubt on your ability to try the issues with an objective mind, or that you have expressed previous views and determinations in an extreme and unbalanced way, if there are real grounds for doubting the ability of the judge to ignore extraneous considerations, prejudices and predilections. So we know the test, and I thought it was useful, and I'll just touch on it very quickly as I'm mindful of the time I have with you, just to compare it to the tests in particular in Australia. We know the Porter-McGill test is the question of whether the fair-minded and informed observer, so that's the objective standard, having considered the facts, again, that's the factual context, would conclude, this is important, that would conclude that there was a real possibility. So would and real. And that sends, it's a debate that you can have as to whether that test places the burden heavily on the applicant compared to the double might, what we call the double might test in Australia. Whether a fair-minded lay observer, so we're back again with the fair-minded and informed, aware of all the relevant facts, that's the informed observer, might, as opposed to our test of would conclude, might reasonably apprehend that there was a real possibility that the judge might not bring an impartial and unprejudiced mind to the resolution. So slight change of words with the double might test, the question of whether that creates a greater deference to the applicant, and whether, if that is so, whether that might be a preferred test if we are indeed to ensure that the streams of justice is pure. So who is this fair-minded observer? I call them the person sitting on the bench in our public squares. What are his characteristics? Well, just again, a summary of all the case law on this. What is the character of this observer? So he's the one drinking coffee, or she's the one drinking coffee in the square. Is someone who will reserve judgment on every point until they have fully understood both sides of the argument. When you look at all the characteristics of this well-informed observer, you would ask, I have to ask the question whether it's more fiction than reality, whether we constructed something just to give, I suppose, a base for us to ensure that we uphold the duty to sit over the question of accounting to our increasingly suspicious and mistrustful publics. Someone who reserves judgment on every point, fully understanding both sides of the argument, not unduly sensitive or suspicious, does not associate with the views of the complainant unless it can be objectively justified. That's the character of this objective, fair-minded person. Knowledge, the knowledge of this fair-minded objective bystanders, someone being well-informed. You would have taken into account the basic considerations relevant to arriving at a conclusion, founded on a fair understanding of all the relevant circumstances. The observer will take the trouble to inform themselves on all matters that are relevant before taking a balanced approach to any information that they receive. The sources of information of that well-informed observer will be chosen with care. Special knowledge. That informed observer will have this special knowledge without necessarily disqualifying themselves from that bystander will be taken to have some knowledge of the fact of these special qualities of the adjudicator, that the adjudicator may properly adopt reasonable efforts to confine proceedings within appropriate limits, to ensure time is not wasted by futile efforts to have that judge recused. This fictitious bystander will be aware of strong professional pressures on judges. That this bystander will not reach a hasty conclusion based on the appearance evoked by an isolated episode of the judge's intemperate remark. Assumptions. The fair-minded observer will assume that a judge, by virtue of his office, is intelligent and well able to form his view or her view, and capable of detaching their minds from things that they don't agree with. Awareness. The well-informed observer will take what they have read into context, the overall social, political, and geographical context before passing judgment. So looking at the case law about these characteristics of this well-informed observer, I have to ask myself the question, how real is it when you listen and you understand a society where perhaps, if we're dealing with a democracy and freedom of expressing opinions and so on, where we would like to think the minority has the loudest voice, and you turn on your radios and you hear all sorts of things from these talk show hosts and some journalists and bloggers, and you wonder to what extent is the well-informed observer actually being influenced by the views of these minority outspoken influencers. And so in small societies, the role of social media takes a very important part to play in, the mind of the public. So there's a disconnect sometimes when I look at this bystander test and what really counts for the public and having trust in what we actually do. I see my chairman is signaling to me that I should be wrapping up.
Thank you, Justice Kukram. It's only to facilitate questions. This presentation has been very, very engaging.
Okay, so what I'll do is just highlight for you as I close. I have just focused on apparent bias, which is one of the troubling areas for us in our small community. And you would find from your own experiences problems with bias applications for recusal on the grounds of your association with other persons in the community. And the real concern should be, is there a real connection between that person and the case and the issues that you have to decide? Social media, we have to be careful of what we do and comment upon on social media, the thumbs up and so on, that can come back to haunt us. And then robust statements in case management. And again, I think we've touched on some of the law on predetermination, and of course, robe disease. I just wanted to show one clip, if I may, Chairman. I thought it might just, as it's a nice little afternoon, show an example of robe disease. And you'll tell me if this judge has expressed himself in such intemperate language that he ought not to adjudicate further.
Whether Lehigh has it.
Fine. Can I then have, now Ms. Kolsky comes back after everything was finished except for those two pieces of paper, his Social Security earning statements, which he doesn't have, and this supposed report that exists for Lehigh.
He gets his Social Security every year indicating.
The earning statement.
He gets his earning statement.
Okay.
He gets it. He gets it every year. So she asked for it. Why didn't he provide it?
He doesn't have it.
He doesn't. He threw it away?
I would presume he did.
Oh, come on.
If you say he got it, Judge, I don't know.
Don't you get it?
No, I don't get it.
You don't?
get it, Judge.
I get it.
I don't get it.
You get it? You get it? Everybody gets it.
Everybody gets it.
I must be the one that doesn't get it.
Social Security sends it to your home
They do.
every year.
They sent it to my home 4 years ago. I haven't received it in the last 3.
Well, when did you become an illegal alien?
Judge.
It comes to you.
Judge, I am going to, that was a totally inappropriate comment.
I didn't mean it. I'm only,
Judge.
listen to me.
Oh, I thought that was a very interesting clip of where, of course, you'll expect an application for recusal to follow. And sometimes when we find ourselves in those positions, it borders on judicial misconduct. We won't go into any depths, but the precautionary principle would advocate the duty to disclose any connections and information, to sanitize your relationships and any issues concerning recusals. I commend Jones and Das as the steps to follow. The ability to make an objection on grounds of recusal can be waived. And of course, we have the doctrine of necessity. I would just advocate maybe for some aspect of reform by thinking over that apparent bias test and the bystander. Perhaps relieving a judge from determining recusal applications to a standing ethics committee or standing review panel. And I just close with some food for thought, which we could come to in the question and answer. And I just will close by saying that for recusals in small jurisdictions, I don't think there's a free pass for us, but rather of heightened precaution. And there's no doubt that we face difficult tasks in maintaining the balance between public faith, trust, and confidence, and our duty to sit. We can only hope that in our approach to recusals, we are mindful of our own limitations and transcend ourselves to see the larger and more important picture of our role in the dispensation of justice, the impartiality of office, the sacred values of trust, confidence, and respect underpinning the rule of law, our legitimacy, and our relevance. Thank you, Chair.
Thank you so much, Justice Kokoram. That was truly an informative presentation. So I'd ask you to briefly stop sharing the screen so as to facilitate the questions from our audience. And I would now invite members of the audience to ask any questions that have come to mind during this engaging presentation. Thank you.
I wondered, Chair, if I could just share these 3 questions to see whether they could answer it now that we've had the presentation.
Certainly, Your Lordship.
Let's see if we could answer that. Maybe it's a yes or no in the chat. If a senior attorney appears before you, she was a partner in your previous law firm which you left 10 years ago, and you still maintain a friendship with her as colleague and mentor, is this a case that you will step aside, or you will still, would you step aside? Would you continue to sit, or would you disclose this to the other parties? And we also have another problem where your daughter has studied law and won a government scholarship and now posted in the AG's department. How do you handle those cases in which the AG is a party? Or what about your presiding on a legal challenge to the constitutionality of the death penalty, which raises the question of, the right to life and, spirituality behind of life, and can man take life, or should that be a matter for God? And you're an established lay preacher in the local church. How would you all deal with these things?
We have one response in the chat.
Yes.
It's from Ms. Misick. Question A, recuse, B, disclose, and C, disclose.
Yeah, that's interesting. And the question, and again, this, sorry to say, there's some of these questions and not really a right or wrong answer, but really our approach. And even when you are disclosing, the question, and I've had this conversation with colleagues, you only disclose if you feel that there is something there that will found a basis for you to step aside. And sometimes some judges might look at number 2 and say, well, you know what, I mean, as par for the course, why should I disclose that, but I again, heightened scrutiny, no free pass in small societies, precautionary principle, I'll accept those answers that you just gave. Yeah. The first one though, we do have this informal rule. I don't know whether you all have it as well, that even after you've left chambers, there's a cooling period. Our cooling period, I think, is 10 years. I think it's either 5 or 10, maybe 5. A cooling period before which you can start doing cases from your old chambers. But one of the things with A, though, is the question of how close is your friendship with this person. I think the key there, I think, for the judge to convince her to say she'll set aside, maybe is that she considers that person a mentor. And so, there's the facts are all important. And if you hold someone in reverence as a mentor, sometimes you may say, okay, well, you give deference to some legal arguments they may make. And how robust will you be in disputing your mentor's comment? And how would it be perceived by members of the public or legal profession? So thank you for your responses. Chair, I'll turn it over back to you.
Thank you very much, Justice Kokaram.
Yes.
So it asks again, are there any further questions from the attendees?
I have one question. Sometimes for example, you have a relationship with someone before you, a friend, and you disclose that, okay, me and this person, we're friends. If there's any objection, I'm willing to recuse, but they said there's no objection. But when things are not going their way, then
Yeah,
they
yeah.
ask for
So,
recusal. So yeah,
very good, very good. So when you have these instances where you disclose and you're disclosing for the purposes of, again, precautionary principle, but you record their consent, and that falls in the doctrine of waiver. And yes, you can waive your right to object to a judge on the ground of impartiality. I'm a bit uncomfortable with the principle of waiver, again, because I defer to the question of ensuring trust in our administration. But you have to balance that with persons making conscious decisions of the judge's ability to sit after full knowledge of any issue that will impact upon that judge's impartiality. So waiver will not apply if some further information is uncovered that you did not disclose. So I think in that situation, you would want to record their consent to you sitting after your full disclosure. I would actually advocate for you to make a record of what it is that you have actually disclosed. So that cuts off any further objections on that ground. I see Mr. Mitchell.
Mitchell Casey,
Yes.
he's made a comment on the questions that you've posed. And he says that in the United Kingdom, part-time judges have people from their chambers in front of them, and this is not seen as a problem.
Yeah.
I think he is subject to full disclosure and discussion.
Yeah. So yeah, so all these are, it's difficult to say yes or no, Mr. Mitchell, as I explained. And yeah, you're right. But I think, and that's why I threw it out to members of the Caribbean community, I think we do have a cooling period in our jurisdictions before people in our chambers can appear before us. And I remember sitting as a judge and routinely young judges coming on, and as soon as they see the law firm of their previous chambers, they just pass the file to someone else. So again, that's maybe because we have the luxury as well of a number of judges. What happens when you have a small pool? Do you have that kind of luxury? So yeah, full disclosure and discussion, safe.
Thank you for that comment, Mr. Mitchell Casey. And I'll ask for a final call for questions now.
But Chair, it seems that the presentation was clear enough.
Yes, it was.
My taught teacher in Cavell University would always end her lectures, has my lecture been as clear as mud? That I will always remember that. So there you go. Thank you everyone for the opportunity. It was a pleasure.
Okay, excellent. So thank you, Justice of Appeal Kokara. And before we close, I'll hand you over to Ms. Tanya Carter, who will give a formal vote of thanks. So Ms. Carter.
Good evening, good afternoon, sorry, everyone, and good afternoon to our presenter, Justice Kokoram. Thank you for your disclosure earlier in your presentation, for fear that I may fall victim of having to recuse myself from giving this vote of thanks for fear of apparent bias. But Honorable Justice of Appeal Kokoram, as always, your engaging presentation has given us much to think about. It has also laid due emphasis on the importance of the role of the judicial officers, and might I say future judicial officers, in treating with scenarios which may arise from time to time, which give rise to applications for recusal, and more so in small jurisdictions. The Turks and Caicos Islands being a small jurisdiction, your presentation was quite relevant and raised germane issues for consideration. You have provided us with much information supported by the relevant case law and how to guide us effectively on dispensing with justice and ensuring that the gold standard is adhered to. So on behalf of Her Ladyship, the Chief Justice, the Chairperson of the JEI Committee, as well as the JEI Committee, we say thank you once again, Justice Kukuram. I now hand you back over to Mr. Emmanuel.
Thank you very much, Justice Kokaram, and thank you very much to all our attendees. We've shared a very brief feedback survey in the meeting chat, and we'd ask you all to complete it before logging off. So thank you very much, Justice Kokaram, and please all join us tomorrow for day 3 of JAI Week. Good afternoon, everyone.